Good afternoon, Your Honors.
Good afternoon.
I'm Donald Caparella of the Nashville Bar. I represent the Kellogg's and the Mahaffeys in this appeal. I'd like to reserve 3 minutes for rebuttal.
3 minutes, that'll be fine.
Your Honor, a map would greatly help this oral argument. Now, this is taken from my brief. It's slightly larger, so it's easier to read, and I'd like to hand a copy up to the court. It's just one page.
That'll be fine. You've
given
one to your.
I wrote on. Did I give you the one I wrote on? I just wrote where it was in the record.
Nice move.
Yeah, you got a brief look at it, but that was it.
Your Honor, as you can see on the map, number 26 there, the Holt Mahaffey farm, that was purchased by Nelle Mahaffey in 1980. In 1983, you see the Robinson property there, number 8, was owned by the Robertson McGill. And Holt Mahaffey, Miss Mahaffey, who wasn't married at the time, got in a lawsuit with the predecessors of the Robinsons, which is the Robertson McGill. And in that lawsuit, the trial court found two things. Number one is that the predecessors owned the Robinson property, number 8, and it reserved specifically an easement in favor of the dominant estate, the Mahaffey estate. And then in 1986, the Mahaffeys bought the Donnell Mahaffey property, and then in 1987, they bought the Cooper Mahaffey property. The first issue in this case is, what was the nature of the easement that the 1983 judgment created? And we submit that that is an easement appurtenant, not an easement in gross. And the trial court erred as a matter of law in interpreting the judgment that it was an easement in gross. And on the map that I gave you, you see there's a purple line. And the easement that we're talking about is that purple line. It takes you from Horse Mountain Road to the 107 acres, that was the Holt Mahaffey property, but it also takes you to the Donnell Mahaffey property and the Cooper Mahaffey property. And the testimony in the record from the Mahaffeys, and there was no one else around in this case other than them, was that in 1980, they began using the parcel, well, it's not parcel 26, but number 26. They began using the purple Holt lane to get to Horse Mountain Road. And when they bought the other two properties in 86 and 87, they also began using the lane to get to those properties. So the Mahaffeys were using the lane to get over the Robertson McGill property from 1980 for that property and from 1986 and 1987 the rest of the time. So that lane continued to be the way that the Mahaffeys got from these three parcels to Horse Mountain Road. The language of the easement that was created in the court ruling says that it is, well, they first of all said that the Robertson and McGills are the owners in fee of the, what is now the Robinson property, but it's subject to an easement over and across said described land for the purpose of ingress and egress to and from land owned by the defendant, Nelle Powell Williams. That as a matter, I'm sorry, Your Honor.
Well, I was going to say, but at that time, the defendant in that suit just owned, it's not parcel 26, but what is marked in black sort of as a polygon, what is that shape? But they didn't, the Cooper Mahaffey property and Donnell Mahaffey property wasn't yet in the hands of Mahaffey. Is that correct, Nelle Mahaffey?
That's absolutely correct.
Okay.
And then in 86 and 87, they bought the other two properties, and they testified, and that part is not disputed, that they used the lane for all three properties. Okay. So number one, it's an easement appurtenant because there's a presumption in favor of easements appurtenant based on this language. And there is a limitation in this easement appurtenant, and the limitation is it describes what it is. An easement for a passageway not exceeding 22 feet in width along the same location as an existing passageway. So looking back in time, it shows that this, for the last 10 decades, 8 or 9 decades, was how everybody who owned this property going back in time got from these properties to Horse Mountain Road.
But,
Please go ahead.
but when this lawsuit occurred, there was only one piece of property that was accessed through that easement, and now there are 3.
Well,
Is that right?
Then there became 3 in 86 and 87, yes.
Right.
And all 3 properties were owned by the same person, the Mahaffeys, and they used that lane. So they used it, yes.
So is that, that's more than the court envisioned, is it not?
But an easement appurtenant can be transferred to someone else, and the Schmutzer case, the Smutzer case, let me get the exact title, says that when Smutzer, it's in my brief, it's a 1984 case, says that when an owner of a dominant estate, like the Mahaffeys were in 1983, buys more property and uses that same easement for their other property, then they can continue to do that as long as they aren't increasing it so much in scope that it creates a burden. Now, the only finding by the trial court was that there was an increase in traffic because the Kellogg's also used that lane. But the courts are very clear that an increase in traffic does not increase the burden.
So there was no finding of an increased burden then?
Well, there was a finding by the trial court that an increase in traffic was an increase in burden, but the case law in our reply brief is very clear, including the Schmutzer case and the Reagan case and some other case, that in order to have an increase in burden great enough to destroy the easement, it has to be something like the 22 feet that this easement is wide would be doubled in size. The case law says, for example, if you have a 10-foot easement, you make it a 30-foot easement, that's an increase in a burden. But just increase in traffic is not enough. And the best example was somebody had an easement, and then they had a 30,000 square foot stable added, and all that extra traffic. And the court said that's not enough of increase in burden. So when you own an easement appurtenant, as the Holt Mahaffeys did, and by the way, this 1983 judgment was recorded in the deed book and register's office. And when the Robinsons bought this property in 2015 and then later began living there in 2017, they were aware from public notice that there was an easement, and the easement was exactly as written in this 1983 judgment. So respectfully, there's an easement appurtenant. And the Holt Mahaffeys, by buying these other 2 properties, can transfer that to them by just creating it. Now, we also have, the dates really matter in this case. That's why I said 26 was bought in 1980. The Donnell Mahaffey and Cooper Mahaffeys were bought in 86 and 87. 20 plus years went by, more than 20 years went by, before the Kellogg's even arrived on the scene and bought that little part right there. So a prescriptive easement was created. And what the trial court did in this case was an error of law, because the trial court actually never analyzed the merits of the prescriptive easement argument. The trial court said that res judicata barred anybody from claiming, after the 1983 judgment, a prescriptive easement. But you can't bar a right from arising in the future when that right has to arise in the future based on the progress of time. So here, there's no question that 20 years went by from 1983 to 2007, which is 24 years, which creates another right that can be transferred and used by the Kellogg's, as well as the Mahaffeys, to that purple lane. So I'm sure my opponent will point out that the court found that Mr. Kellogg lacked credibility about some of his testimony. But his lack of credibility matters not at all to the legal issues in this case, because when he came on the scene in 2007 and bought that property from the Mahaffeys, property that had historically used that purple line there to get to Horse Mountain Road, The easement appurtenant had been created back in '83, and the prescriptive easement had been locked in because 24 years had gone by. So it doesn't really matter what his testimony does at all. Now, as a practical matter, he has 8 more years tacking on to the 24 years, so you have almost over 30 years of prescriptive use.
Now, the proof here was that the Kellogg's stopped using the lane for a while, right, for construction of a house?
The proof is that when they bought the property in 2007, the part above the lane, the black line there, was not a great road. It was a road, but it was not a great road. And they didn't use that very much. And they also testified that when they bought the property from the Mahaffeys, they were aware that was going to be their long-term use, because eventually their route off the property to the other side was going to go away when they sold that property. So they did not use it very much for the first 6 or 7 years. But then when the piece of property got sold to the east of them, cutting off their route to this other lane, they had to, that was the only way they could use it.
Well, that was going to be my question. Where is the other lane on this map?
If you see the arrow that goes to Kellogg,
Yes.
I can't read what that road is, but it's that arrow going up to the right shows where the other road is.
I see.
But they
Okay.
have no way of getting to that anymore.
So, yeah, they would have to cross over Donnell Mahaffey.
Well, it's no longer Donnell Mahaffey, it's owned by
Okay.
somebody else now. The Mahaffeys sold the property to the east of them, north and east of them, so the Kellogg's had no way out at that
So
point.
the Kellogg's are now landlocked. But
Essentially, they are, yeah. They would have to get access to go over the Cooper Mahaffey property, which is not even owned by Mahaffey's anymore. It's owned by, I think, Brent Walker or somebody else. So they don't really have a good way to get out. Now, this is not an easement by necessity case.
Okay.
This is, while we submit that under our implied easement argument, this is not, they don't really have any good options, but we don't have to show that this is our only way out. That's not one of the issues in this case.
All right, let me, before you time,
Yeah.
your issue 1, did the trial court err as a matter of law when it interpreted the recorded 1983 judgment to find only an easement in gross? If we should find the trial court did not err in that interpretation, I understand your position is did, but if we should find that it doesn't, or it did not err, what does that do to the other issues?
They're totally independent of that ruling, Your Honor. The prescriptive easement issue stands on its own because we have more than 20 years by the Mahaffeys.
So you're,
and the
okay,
Kellogg's.
that's the two things, the prescriptive easement
Stands alone.
and alone, and then the interpretation of the 1983 easement.
Easement by implication is the third.
The implied easement also stands alone because of the long history of this use. So
Thank you.
essentially there are 3 routes for the Kellogg's and Mahaffeys to win. Any one of them works, but the easiest one is the easement appurtenant, because under the Schmutzer case, buying these other 2 properties, using them, you can essentially, when you own an easement appurtenant, you can transfer it to subsequent purchasers.
The only one missing is easement by necessity.
Yeah, I don't have that argument in
Okay.
this case and not making it.
All right, you have your time for rebuttal.
Thank you.
Hear from the appellee.
Your Honors, thank you. John Richardson from the Lincoln County Bar. And Your Honors, Mr. Cabarella's map is very helpful, and you know, I'll start with that. You've got it in front of you, and I might point out also that I've got one in the brief that I filed under tab 1 that is there. I'm going to address something right away with that. And I'll go to the issue of easement, a pertinent easement in gross first, but I'm going to point out to Your Honors that the other access, and you'll see it, like I say, on tab 1 of my brief, it has Bell Buckle War Trace Road. And Bell Buckle War Trace Road is where the Kellogg's, who are located far to the north of my clients, the Robinsons' property, that's where they accessed their road, accessed their property when they purchased it. And that's where they accessed they purchased the property in October of 2007. and they accessed their property from Bell Buckle War Trace Road, not Horse Mountain Road, way down to the south. They accessed it from Bell Buckle War Trace Road, and they testified to that, answered requests for admissions and interrogatories, and confirmed it at trial. They accessed their property from 2007 until 2012 or 2013 from Bell Buckle War Trace Road. And Ms. Mahaffey also testified. Ms. Mahaffey, the late Ms. Mahaffey now, unfortunately, she passed, which is very unfortunate. But she had testified at trial that she sold two other parties property off of this same farm up here that the Kellogg's bought property off of. And both of those properties, there being people by the name of Cook and West, they access their property still today from Bell Buckle War Trace Road. Having said that, it's our position that the easement, when we talk about an easement and a pertinent or an easement in gross, we feel like the court clearly did not err and that it is an easement in gross. And I say that, Your Honor, Mr. Caparella, and he did an excellent job in his brief. I applaud him. He's done a wonderful job. I would respectfully disagree that his brief says, that the court's order of 1983 just dealt with ownership of the land, and that's just not the case. And as the court in 1983, we're asking that be upheld, as well as the present trial court, Chancellor Cox. But the 83 court very effectively dealt with what we're calling the passageway. It very effectively dealt with that in the language that was there, and it talks about a passageway 22 feet in length to get to and from, to get you from Horse Mountain Road, which is right here, get you to and from Horse Mountain Road up over the purple portion to the Holt Mahaffey farm, which has got the 26 on it on Mr. Caparella's sheet. And again, that's the only property that Nelle Mahaffey owned at the time. She owned nothing further, nothing else. And it got her to and from that property. And I'll go one further. Testimony at trial was also from Surveyor Mike Gooding, that when he pulled all the old deeds, being the Holt deed, the Shriver deed, and the Shriver deed is actually the deed that the Kellogg property came off of. It's property that Miss Mahaffey bought in 1986. But the Shriver deed has no mention of a lane at all. The Holt deed does mention a lane. However, that lane stops, as my tab 1 shows, right here before you even get up to the Holt Mahaffey farm. So without the court's order in 1983, Miss Mahaffey doesn't even get to her property. She doesn't even get there. And the order, in that order, it sets out language, and that language it says it's further ordered, adjudged, and decreed by the court that all claims of ownership in said land described by the defendant, Nelle Powell Williams, be and are hereby removed, and she and the other defendants and their respective agents, successors in interest, are hereby perpetually enjoined from trespassing upon said land, or instituting any action, or making any claim to said land, or interfering with plaintiff's use and possession of said land. I would point out to your honors that it limits the use to Nelle Powell Williams in the court's 1983 order, and goes further and actually perpetually enjoins others from trespassing on the land, and enjoins them also from instituting any actions or making any claims to said land. And I think that clearly hits 2 points, Your Honors. It not only hits the easement in gross, and yes, I understand that easements in gross are favored over, easements are pertinent are favored over easements in gross, but that doesn't mean an easement in gross has to fail. Easements appurtenant also are not supposed to allow new and additional uses that aren't intended when the original easement is created. And that clearly would be what would be happening here if we allow Kellogg from way up north to cross down and connect and come in and out, because that clearly was not an intended use in 1983. It couldn't have been, because Miss Mahaffey didn't own anything else. And it's my position, Your Honors, my client's position also, I lost my train of thought there, but that it's not that it cuts off a prescriptive easement also, because it clearly, not only because of res judicata, but it clearly, the language here, to me, seems to just jump out and say, look, you know, they're cutting everybody off. They're saying, look, the defendants, their agents, the successors in interest are enjoined from trespassing, and you can't institute another action or make another claim. And I think it's clear. It says you can't interfere with the plaintiff's use and possession of said land, not only ownership, but you can't do it. And clearly, res judicata, Your Honor, states that, you know, if it's something that should have or something that could have been argued at the original trial, and there was no better time. Chancellor Cox nailed it when he hit it in his order. And he said, you know, there was no better time. If they're going to argue for a prescriptive easement, there was no better time than 1983. There just wasn't. I mean, this is when they should have done it. And, you know, I wasn't there in 1983, but it looks to me like they may have when I look at the order when Chancellor cuts them off. But I think it's clearly an easement in gross limited to Nelle Powell Williams, because it states that it's limited in the order of 83, and it states the name of Nelle Powell Williams. And then furthermore, you know, I cite in my brief the Calico.
But did other deeds outside of the chain of title from Nelle Mahaffey reference this 83 judgment?
Did the other deeds?
Did other deeds outside of the chain of title from Nelle Mahaffey?
Not that I'm aware of, Your Honor. I don't want to misspeak. I haven't read all of those recently. Not that I'm aware of. I know that the deed to the deed from Nelle Mahaffey to the Kellogg's states in there that the property of the Kellogg's is subject to, and it says it that way, subject to an easement recorded in Deed Book 156, page 1, which ultimately is that, and that's where the judgment.
And that's the judgment.
The 1983 judgment is, but clearly, and even the Kellogg's testified at trial that
so what's the purpose of that then in that deed?
The purpose of that, I think it's just clearly an error in the deed, because
Didn't need to reference it all, is what you're saying.
It didn't need to reference it. I do all kinds of title work, real estate work. I know that's not in the record here, but I mean, it's clearly, and all the parties testified, the Kellogg's and Mahaffey said, no, it's clearly not, the 9.76 acres that Kellogg bought is clearly not subject to any easement down here. I mean, it was just and the Kellogg's also again testified, look, we came in and out from Bell Buckle War Trace Road until 2012 and 2013, and they want to argue about continuous use over the past 20 years, and the testimony at trial there, when I get to prescriptive easement, Your Honors, is, you know, they talked about having a cattle operation, maybe running some cows, but Miss Mahaffey testified at trial, and she said, look, the only thing that road was ever used for was to get me to and from the 107 acres. Her husband, Mr. Mahaffey, said that's the way he understood it as well. Of course, he wasn't married to her when she bought it, but he said that's all he understood it was to be used for, and they both testified nobody else had crossed their field to use this road until they gave the Kellogg's the right to do so. And the Kellogg's, ironically, they're the ones that drew their own easement. Pro Se drew their own easement in 2015, as you'll see in the record, and Harry Kellogg drew it, and he puts his name at the top. When it says prepared by, it says Harry Kellogg. He lists his address as 774 Bell Buckle War Trace Road. Well, not only does he come in and out from Bell Buckle War Trace Road, he gets all of his utilities from Bell Buckle War Trace Road, and he confirms all that in requests for admissions that are all in the file. But he draws his own easement, and he puts in there that it's to establish, and he uses that word, to establish a passageway. So he's trying to establish something, and he's trying to establish it in 2015. And I mean, that was odd to me as well. So I mean, I think that clearly speaks to the fact that there's no prescriptive easement. There's no 20-year time frame. And then the grandson of Nelle and the grandson of Nelle Mahaffey, Brent Walker, who's taken over the estate now, he testified, and there's testimony that he gave, and it's in my brief also, you know, he stated to the court, you know, why would anybody use that passageway? Why would anybody use that easement? Of course, he was out there when he was a kid. He said, you know, it was all grown up. He said, that was all grown up. He said, I don't know why anybody would spend any money to try and cross over something that's all grown up. They had another way in and out that went around some pond out there. But that's testimony from the grandson of, you know, why would you spend money and use it? I mean, it's grown up when I was a kid. And then the, you know, the issue of the implied easement, great argument, but I mean, it's got to be long established. It's got to be, you got to show that it was meant to be permanent. You've got to show that it's beneficial to the land that's retained. You know, it's just there's nothing beneficial about this purple area to the land retained by Kellogg up here. I mean, it doesn't. He's got to cross over another field that Ms. Mahaffey testified to, and she said this at trial too. She said, that's just a cow pasture. And when I asked her, she said, there's no way anybody can cross that land every day. I mean, that's testimony she gave that's in the record. She said, you know, that's a cow pasture, and you can't cross that every day. There's no way you could do it. And she also testified that she was had 10 years of real estate experience and was well versed in easements. Is what Ms. Mahaffey testified to, and she clearly stated, look, I just use that to get to and from my 107 acres, and you know, it'd be my argument that, you know, if we allow people up here to start coming down here and using an easement, that there absolutely was never an intended use of getting up here, way up here to the north. But I mean, way up here to the north where Kellogg is, and that's why they came in and out from Bell Buckle War Trace Road. But I feel like, you know, it'd be opening Pandora's box. And Mr. Caparella does a great job of pointing out the, I think it's the, I draw a blank, the Schultz case, I think it was, I may say, Schultzer case, talking about how you can, it doesn't overburden an easement when you increase the use. And I've looked at that case, and it's an interesting case. It's where some folks owned a residential easement, and then later on, they converted or it got converted somehow to become a commercial easement, and they started running a lot more traffic on it up and down through there. Well, I mean, we don't have an easement going all the way up to, you know, and the court in that case, Court of Appeals, found that it wasn't overburdening it. But there was an intended use for that easement to get in and out where they were going. There's no intended use in this easement in 1980 or 83. All we're doing is getting to Nelle Powell Williams because of the fact that's all she owned at the time. So not only does it, I argue that it overburdens it, but if it doesn't overburden it, it's certainly not an intended use of that easement. And to create that and allow that to happen would have been an error by the court, is our position. And then slander of title, I know I've got 58 seconds left. Slander of title, I mean, it seems clear to me that by creating an easement over property that you don't have any ownership interest in, she didn't have, Ms. Mahaffey didn't have the right to give Kellogg's the authority to come in and out of there, them, their family, whoever, but they recorded not one, but two easements to themselves, signing deeds and recorded them, and that's what slandered the title. I think they did it maliciously. I think they did it without, they didn't have the right to do it. I mean, it'd be like me conveying myself an easement over the three of you all's yards. I said, well, I need to get to my cabin back there behind you there. I'm gonna just give myself an easement and come right over you. I mean, that's what I'm gonna do. I mean, it slanders it when I record that. And, that's our position is the court did not err, and that the position of the 83 court and the trial court should respectfully be upheld. Sit down because my time's up unless y'all have questions.
I hear none. Hear from the appellant rebuttal.
Your Honors, the Kellogg's were on notice when they bought the property of this 1983 judgment because it was in their deed. And the Robinsons were on notice of the 1983 judgment when they bought their property in 2015. So the question comes down is, what does this easement language in the 1983 judgment mean? It's an issue of law that this court does not need to defer to the trial court on. And the, I'm going to quote something correctly here. It's a privilege for a lawyer to quote Latin in an argument. There are limitations in this easement, and the only limitation is that it's 22 feet in width along the same location as an existing passageway. So, Judge McBrayer, that's reaching back in time to the previous passageway and supports our implied argument. This is something of long standing, and after all, it goes back to a 1935 deed, 1912 deed, that this Holt Lane was there. So that's another thing supporting that. But since you have a limitation on this easement, and nowhere in this limitation does it limit it to the life of Nelle Williams or Nelle Mahaffey, then under the canon of interpretation, expressio unius ex exclusi alterius, the expression of one thing implies the exclusion of others. There are no other limitations to this easement in this 1983 judgment. Therefore, it must be presumed to be an easement appurtenant. And it's certainly more definitive than the other cases that have held that. Yes, Your Honor.
Doesn't the paragraph that they point to that talks about, successors, agents, et cetera, isn't that really in regard to the bigger question of some ownership of the property?
Yes, there's the lane and there's the land.
Yes, and that paragraph looks to me like it might refer to the land rather than the lane.
Yeah, the court...
Is that how you interpret it?
Yes, the court resolved, the 1983 court resolved a fight over who owned number 8, what became the Robinsons' land. And the court said, Ms. Mahaffey, you don't own it, but we're reserving you an easement to and from the land, which is an easement appurtenant, and nobody can trespass onto the land. It'd be ridiculous to give her an easement to the lane and say, you can't trespass on the easement that we just gave you.
Right.
So therefore, it has to be, the judgment is addressing the lane and the land, and that's the restrictions, and respectfully, my opponent is conflating those two things. Now, so by the time the Kellogg's came on to the land, an easement appurtenant existed. They had the right to transfer it to subsequent purchasers in 2007, and also a prescriptive easement existed as well as an implied easement. So the relief that we're asking for, Your Honor, if I may just close with that, is reverse the trial court and find that the Kellogg's and the Mahaffeys have a right to use the purple line, the Holt Lane. Secondly, that the Robinsons are enjoined from preventing them from using that use, and also that you ordered the trial court to allow the money that was awarded for slander of title to be refunded. They posted that in the trial court as a stay, and you asked the trial court to remand to the trial court to give that money back to the Kellogg's and the Mahaffeys. Thank you, Your Honor.
Of course, thanks to counsel for your briefs and your oral argument today.